Court of Protection, which has unfortunately been labelled the secret court by the press, is a court that has been set up to protect the interests of people that lack capacity to make decisions for themselves. The types of court case that the Court of Protection deal with are vast and very varied. They can deal with applications from a very mundane application for the appointment of a deputy to applications regarding whether or not a life support machine should be turned off. They deal with all applications where the person who is the centre of the application lacks capacity to make those decisions for themselves. There are many different types of applications that can be made to the Court of Protection. The main applications that we bring are applications regarding best interest decisions. These are applications that will be brought by the local authority or a family member for a determination about, for example, where a person should be living, whether they should be living in a care home or whether they should be living in residential care, and whether they should be receiving certain types of treatment or contact with family members. A different type of application is an application for a statutory will. An application for a statutory will is required where a person lacks capacity to make the decision to make a will for themselves, but the circumstances prescribe that a will is necessary. For example, their wife has died since their last will, or they have received a substantial amount of money since making a will, or they are intestate. A third sort of application is an application for the appointment of a deputy. There are two types of deputy that can be appointed. The first is a deputy for financial affairs, and the second is a deputy for health and welfare. The difference between these two types of deputy are that a deputy for finances will be a deputy that is appointed by the court to look after the finances and invest the monies of a person who lacks the capacity to make these decisions for themselves. The appointment is akin to that of an attorney under a lasting power of attorney, except for the fact that the person who owns the money doesn't have the capacity to make the decision to appoint somebody to manage their finances for them. Instead, the Court of Protection makes the decision to appoint a person to manage their finances. The second sort of deputy is a health and welfare deputy, and these sorts of appointments are much rarer. Only about 200 or 300 health and welfare appointments are made every year, and it tends to be in situations where the person who the decisions need to be made about has a long-standing and chronic healthcare condition that requires regular decisions to be made about them. I shall now go into detail about making a deputyship application for property and financial affairs. A property and financial affairs deputyship application can be quite a lengthy and arduous process. It can take about 6 months to complete, and it costs about £2,000 to £3,000 in solicitors' fees, in addition to a £400 court fee. Whilst these fees and this timescale may seem very high, the reasons for it are that the court application paperwork is very lengthy and very detailed. We would initially need to meet with you in order to take information about the person who cannot make decisions for themselves. The sorts of information we would need is details of their bank accounts, details of any property they may own, any business they are interested in, whether or not they've made a will or previously made a lasting power of attorney, and details of all family members that will need to be notified of the application. Once we have all of these pieces of information, we will be able to send you the completed papers, which are generally forms COP1, COP1A, COP3, COP4 and Form COP24, so it's quite a lot of papers out to you and for you to confirm that you're happy with the contents of them and sign them as a prospective deputy. If you do not wish to act as a prospective deputy, then a professional can be appointed to act as a prospective deputy. Once the papers have been sent into the court will issue them, and this means that they will send a copy of the court application to key family members, such as a spouse or a sister or a brother, and they will be able to object to the application if they do not think it's appropriate for the application to have been made. Additionally, they will notify people who are less close family members that an application has been made. There will then be a 21-day wait whereby people that are named as respondents or notified persons can object to the application. Unfortunately, the court is very busy, and at this point, after that 21-day wait, there is generally about a 4-month wait to see a judge. The judge will then consider the application and the papers and make a decision as to whether or not to appoint you as a deputy. If they do not wish to appoint you as a deputy, they can make an appointment of a professional deputy or appoint a different family member to act as deputy. If there have been objections along the way, then it's possible for the application to become contentious, and these are the types of hearing that you tend to hear about in the press. When you make these applications, you want a legal team by your side that are experienced and knowledgeable about such matters. Withy King have been there, done it, and got the t-shirt. Our team consists not only of solicitors, but a chartered accountant, which means that we are able to deal with applications no matter how complicated the personal and financial circumstances of the person who the application is about. The team are regularly asked to contribute to articles on court of protection matters and are regularly asked to speak at presentations and conferences nationally on issues regarding deputyship. The team is nationally ranked in Chambers Directory as leaders in court of protection work, and it also is a member of Solicitors for the Elderly and Action on Elder Abuse. I personally am a member of the Law Society Committee on Wills and Equity, which means that I have a direct line to the government on advising on policy issues, and I'm also regularly in correspondence with the Office of the Public Guardian, who is the government body that monitors deputies.